everyone. Welcome to our panel discussion on bail strategies in economic offences. As we all know that arrest and bail are critical aspects of any crime, but the determination of bail depends on numerous factors like nature of offences or severity of punishment, etc. And today we are going to explore bail strategies in economic offences. To understand this better, we have experts with us. We have Mr. Vivek Sood. He is senior advocate at Supreme Court of India, and he is expert in criminal and commercial matters. We also have Mr. Samarjit Pattnaik. He's partner at Karanjawala and Company Advocates. We welcome you both on the panel, sir.
Thank you.
So, starting with the first question, Mr. Pattnaik, and also the basic one, can you help us understand the distinction between the economic offences and the traditional crimes like homicide and robbery in the context of bail?
Okay, so criminal offences generally are categorized into various types and nature of offences. And the new evolving offences, which we generally term as economic offences, socio-economic offences, or probably could also very popularly known as white-collar crimes. White-collar crimes or social economic offences are slightly different from the conventional offences in the sense that from the aspect of who is guilty, if under the conventional offences, generally the burden of proof is for the state. It's on the state for the prosecution to prove the guilt. However, it's the other way around for the economic offences. In the economic offences, to start with, the accused is presumed guilty, and the onus of rebutting the same is on the accused. That's majorly the criminal principle that is governed with. Whether you talk about the very basic economic offences like a NI Act, say for example. In the NI Act, the same principle of law applies, that the onus is on the accused for him to prove his innocence. And the same would apply also in the most grievous type of economic offences. And today, the most commonly heard of economic offences would be those offences which are under the PMLA Act for money laundering, etc. And even in those kind of much higher pedigree offences, also the presumption is on the accused. And very recently, the Honorable Supreme Court has, even approved of the said fact after a lot of challenges to the provisions of the PMLA Act. And much, I don't know, I would rather say much to the dislike of the lawyers, but well, I mean, in the profession, we would want to fight it out for our clients as well. So the Honorable Supreme Court has actually upheld most of the provisions of the PMLA Act, including the powers of under the PMLA Act for arrest, and also upheld the conditions of stringent conditions of bail. So these are the kind of offences which are called economic offences, where primarily there isn't any, there is obviously a lot of preparation to do economic offences, but in the sense of it, there isn't a mens rea to it. And mostly these offences are committed by privileged people, I would say. I mean, there could be banking offences, there could be offences under the income tax, wealth tax, the NDPS Act. So these are the kind of offences, and the bail conditions in most of these economic offences, of course, are provided for under specific and special acts. So they fall under special acts, and these special acts have their, apart from the provisions under the CRPC, have their own additional guidelines, own additional parameters as to how bail is to be granted, and what are the higher levels of due diligence that is required in terms of granting bail in these kind of offences, as opposed to the more conventional offences, where it is purely and mostly guided by the bail regulations as provided under the CRPC. So that, I would say, is the basic difference between the economic offences and the more conventional offences, which are primarily guided by CRPC and are offences under the IPC.
Okay. Thank you so much for clearing the distinction between the both. And now coming more towards economic offences, Mr. Sood, can you help us understand the bail parameters when it comes to economic offences in the country?
First of all, I am very happy to be on this platform and sharing the platform with my colleague Samarjit, who's the partner at Karanjawala. I would divide the parameters into two categories. One is the practical, one is the common parameters of bail that apply to all offences, traditional offences and economic offences. Firstly, the seriousness of the offence and the nature of evidence is an important factor. It's an important parameter whether to grant bail or not. Whether the investigation is complete or pending is another parameter. Another parameter is whether the trial will take a long time or not. How many witnesses will be examined? What is the length of the expected trial? Another parameter that is important is whether the applicant, the person who is seeking bail, whether he is likely to influence witnesses or not. Then whether there is likelihood of tampering with the evidence or not. Then absconsion, the chances of absconsion of the accused is also an important factor, which is popularly called the flight risk. What is the risk of the accused fleeing away from justice, running away from the country, or going underground? Then the criminal antecedents of the accused are also important as a factor whether bail should be granted or not. The length of custody, the need for further custody. So these are some of these 8 or 9 common principles that apply to all kinds of offences. Now I come to economic offences. Now let us look at it from a very practical perspective, based on my experience of 3 decades on the criminal side. I have been able to classify economic offences in 3 categories in the context of bail parameters. One is where the victims are multiple, so multi-victim cases, where the victims are home buyers and the builders are the accused. Now, there is zero tolerance in such cases. Bail is next to impossible, or I would say bail is highly improbable. It is very difficult to get bail in multi-victim kinds of cases. The second type of cases where there is near zero tolerance, where there is cheating, forgery, criminal breach of trust, and these are blatant cases. Suppose an accused tries to sell his property to 3 people. Now these are open and shut cases of cheating. So there is near zero tolerance in terms of grant of bail. Then you have the third category, where the disputes, where the facts are disputable, where there are civil elements in a case. So there the courts are more liberal in granting bail. So these are some of the parameters. Of course, we can't pigeonhole parameters, in slots. Every case presents its own complexities. It depends upon the facts and circumstances of each particular case. So therefore, these are some of the parameters that are considered by courts whether to grant bail or to deny bail.
Thank you for sharing that. And Mr. Pattnaik, as in the first question, you mentioned the PMLA cases. So can you please throw some light on the bail parameters when it comes to PMLA cases?
So, even though Mr. Sood is an expert, I will try my best to just briefly state. Now, under the PMLA, the power of arrest has been provided under Section 19, and it also says that, so under the PMLA, we could probably categorize bail into two different parts. One is bail of an accused who is already in custody, arrested and in custody, and bail of an accused who is not in custody in a case and in a circumstance where, say for example, he's not been required to be taken into custody during investigation, and a charge sheet has though been filed against him. So primarily the law governing the bail under PMLA Act is provided under Section 45 of the Act. Now, Section 45 of the Act, like Mr. Sood had just mentioned, that the few parameters in a situation of bail that a court has to consider are probably referred to popularly as the tri-conditions, would be whether the accused is at flight risk, whether there is any chance of the accused evading the process of law, not being available to the concerned court where the prosecution is going on, and thirdly, if the accused is in a position where he can influence witnesses. So these are the three important parameters as Mr. Sood had just mentioned, which in any bail scenario, whether economic or non-economic offences or conventional offences, the court has to consider. But apart from these conditions, the PMLA Act, being a special act, has also prescribed for two very stringent conditions which have to be satisfied for the grant of bail of an accused. Now, under the PMLA Act, the prosecution has to be given a chance to oppose the bail. It means that the prosecutor has to appear and the prosecutor has to oppose the bail of the accused person. And irrespective of the fact that whether to the subjectivity of the petitioner, to the public prosecutor, that he opposes or chooses to be lenient. And the second condition would be to the satisfaction of the court, that the court itself would have to see whether prima facie a case is made out or not, whether the accused is guilty or not, and if enlarged on bail, whether he would be in a position to either continue the offence or any other witness or any other violation that he might be in a position to do. So these are called as popularly as the twin conditions, which are to be satisfied in each and every case in a PMLA matter. Now, this apart from other provisions of the PMLA, Section 45 was also under challenge, and the Honorable Supreme Court has upheld the constitutional validity of this. Primarily, this was challenged because the courts, in a lot of judgments, and also in the famous judgment of Nikesh Tarachand, the Honorable Supreme Court in 2017 had come down heavily on these twin conditions to be unconstitutional, violative of Article 14 and 21, and had struck down and held the section as unconstitutional. Subsequently, there was an amendment, a parliamentary amendment, which made a few changes by tweaking of two lines, two words in the PMLA Act, and made this and brought it alive again back. And over the period of time, there have been various courts, high courts, special courts throughout the country have been taking, I would not say consistent, but varied views on the aspect of Section 45 and the applicability of the twin conditions. So now, anyway, the Supreme Court has put that into rest, and with the amendment also, each and every accused who is even independently without a predicate offence has been charged with under the provisions of the PMLA Act, then these two twin conditions will apply. So it has rather made it more stringent, I would say. However, there is a variance under the PMLA Act. In case there is no arrest of the accused during the course of investigation, and say, for example, a charge sheet is filed, even at that point of time, accused has to apply for regular bail. Now, when the accused has to apply for regular bail, the law as it stands slightly varied to what has been held by the Honorable Supreme Court now in terms of the twin condition of Section 45. The law has been settled in Siddharth versus State. That is, I think, that is an earlier judgment of 2021. And subsequently, it has been followed in a later, I think it was December 2021, when until judgment has upheld the position that even though the right to the investigating agency, to the department is there, and under Section 170 of the CRPC, they have a right to arrest, and the offences being non-bailable, for each and every case where during the investigation there was no requirement of an arrest, for the sake of an arrest should not be made. And that is where the distinction lies, that if there is no arrest during investigation, then the law is very much there that there is no necessity to take the accused into custody. So that is a little variance and little relief. And the third point I'll quickly make is that even after the Supreme Court judgment in the recent judgment where it upheld the constitutional validity of the PMLA Act, there have been certain instances, I think one in Bombay I can remember clearly, where our Delhi High Court. So in these two instances, in the Bombay matter, in the special court in Bombay held that if the predicate offence itself, the main offence under which the accused was charged with, and that offence itself fails, then standalone the PMLA Act will not be applicable to the accused. So in that particular case, this is a recent case, in that particular case, the accused were given interim bail. And another scenario of the same position is that in case it is important to establish the fact that even from a predicate offence, a person is, say, for example, charged under 420. Now, the person might have been charged under 420 or for cheating, for criminal conspiracy, for committing an offence. But till the time, there is no evidence to show that there is any money which is received out of that offence, which is primarily what PMLA focuses at, then the offence under the PMLA Act cannot be attached to the accused. So these are the various scenarios under which, under a PMLA Act, accused is entitled to and can, in a case-to-case, apply for a bail.
Thank you for sharing that. And Also, Mr. Sood, from your experience, we want to understand like what are the bail strategies one should adopt while they are representing the accused in economic offences.
You want me to reveal the secrets? The secrets of obtaining bail. No, that's not in good humor. So, strategies, bail strategies in economic offences, first of all, depends upon case to case. But some of the common strategies which I have followed over a period of time and which have yielded some results. First of all, I have always tried to highlight that the case is based on documentary evidence. So why do you want him in custody? In a case of cheating or in a case of forgery, criminal breach of trust, most of the economic offences are based on documentary evidence. So I have tried to highlight this in many cases. Secondly, I have highlighted, for obtaining bail for the accused, that these are old transactions, transactions which are 10 years old or 5 years old. So why should I remain in jail during the trial? I will face the trial. Yet another strategy, in cases which are blatant, where you feel as a defense lawyer that prima facie a strong case is made out by the prosecution. A man who has sold a property thrice, for example. Defenses are limited. We know within that the defense is very limited or it is not a strong case. There I have used this tactic of depositing the disputed amount in the court. Normally I have said that, okay, we will deposit 50% of the amount in the court. Whoever wins the litigation takes the money. To show our bona fides that, we are not running away with the money. Another strategy which I have adopted, and it is adopted by defense lawyers across the spectrum, I have always tried to highlight the civil elements of these cases. That this is typically a kind of a civil case which is wearing the clothes of a criminal complaint. Why this civil litigation is pending or why a civil suit has not been filed. I have used this argument very frequently. Another argument which I use is that whatever is the allegation is a matter of trial. These are issues that will be decided at the stage of the trial. Every accused is entitled to presumption of innocence. The onus is on the prosecution and the accused has to only probabilize his defense. Then, in cases where I find that, there is grave difficulty in obtaining bail, then, we try and have the matter shifted to mediation and try and settle with the complainant once and for all. When you feel you're totally cornered and it's next to impossible to get bail, so then you surrender. Then you say, fine, we'll settle with the complainant and, give him his property or pay back or do something like that. I have also highlighted Sanjay Chandra, frequently. In Sanjay Chandra, the Supreme Court has said that irrespective of the merits of the allegations, bail is the rule and jail is an exception. So, I have used that Sanjay Chandra argument very frequently. Then these days, Samarjit will agree with me, Arnesh Kumar has become a high point. Why have I been arrested? You go with Lang Par as a defense lawyer. Why have I been arrested? Why have I been arrested? You start browbeating and keep, highlighting Arnesh Kumar repeatedly. You keep chanting Arnesh Kumar again and again, so that maybe the liberal veins of the judge are activated and bail is granted. Now, there is an unwritten code also. Some of these strategies are, secrets. Let me reveal those secrets also. The roster plays an important role. Who's the judge? Who's the judge? And then, timing is very important. Moment investigate, there's an FIR, investigation is going on. So there is a time when everything is heated up. Don't apply for bail in that phase. You will get a rejection. So timing, the way Virat Kohli, he chooses his stroke. It's all about stroking the ball. It's not about hitting the ball with a danda or something. So you have to stroke the ball for a 4 or a 6. And then, with experience, you come to know so many things. For example, there is an unwritten code. Samarjit will agree with me that sometimes the lower court judges will say, Mr. Sood, the stakes are too heavy. You go to the High Court and obtain bail, So there's an unwritten code where the High Court judges, or the superior courts, they feel कि तुम ही सारी bails grant कर दोगे तो हम क्या करेंगे यहाँ पे. So this is a very unwritten code. So, with experience, you understand the pulse of the criminal justice system. And at the end of it, bail is, it is on a case-to-case basis. So, in the corridors, in the canteen, we discuss bail is highly discretionary. A judge has 5 reasons to grant bail in his right pocket and 5 to dismiss the bail in the left pocket. So you try and take out the bail from the right pocket, and you try and keep the judge off the left pocket. And that's the best way I could have, put the bail strategies.
Thank you so much for sharing your strategies. And lastly, I have a common question for both of you. Right now, how are the courts maintaining the balance between the personal liberty and the interest of the larger society when it comes to the matters related to economic offense?
So, courts are very smart. Courts are very smart. Now, in my view, I feel bail justice should be left to the discretion and wisdom of the court. I don't agree with until, where the Supreme Court has said that we need a separate code of conduct, or maybe we need a separate bail code. It all depends upon a case-to-case basis. For example, the people who are accused of exhorting the main accused to stab the victim. Now, we all know exhortation is a weak allegation, and it is generally made to falsely rope in as many people as possible. Now, in a bail code, obviously they will say no bail for 6 months in 302 types of cases. So bail, in my view, should be left to the wisdom of the court. I don't agree with Section 45. Courts are smart enough to deny bail in cases where the accused does not deserve bail. Why have those twin conditions? And it is next to impossible to prove, at the nascent stage that the man is innocent. It's so difficult to prove. So therefore, and then courts are the best to balance liberty with the security of the society. And courts are doing it. You have these cases like Amrapali, etc., balance the security of the society, interests of the society, and the interests of the accused. So that's how the courts are maintaining that balance. Courts look at the stage of investigation, the gravity of the allegations, the stakes involved, the number of victims, and at the same time, presumption of innocence, bail not jail, length of custody. So the courts are able to strike some kind of a balance, in bail justice.
Very well put by Mr. Sood. Of course, that's why I gave him to start on this answer. Absolutely. I think what's the role of the court should be left to the court, and it's high time actually within the judiciary we try giving credit to the judiciary that they have and they are capable of distinguishing from case to case and from situation to situation. For the same accused, they might have refused bail 6 months before on a different scenario. Say, for example, on the stage of investigation, if it's a builder buyer kind of a dispute, then the amounts paid back to the home buyers, whatever it could be. But the same accused who could have been refused a bail 6 months, 1 year back, could be given a bail after a year. So that's the wisdom of the court should legally be challenged, not otherwise. And the very fact that we see the kind of judgments that come in, which clearly shows that how by making a standard principle for all courts that it's bail and not jail, and an accused is innocent till proved guilty. These are the kind of phrases that has been developed over the years by the judiciary, which itself shows that the prime importance is given to the fundamental rights of the citizens. At the same time, though, like Mr. Sood, don't agree with the twin conditions and don't agree with the stringent bail conditions, not only of PMLA, but maybe of various other special acts. But from the point that while the same court is saying bail, not jail, and innocent till proved guilty, is also trying to, for economic offences which affects the masses at large and for and affects the economy of a country in serious frauds, is also trying to put certain extra conditions at times. So hence I think the courts are thinking, the judiciary is thinking, we should leave it to the wisdom of the court, and the courts are the best judges to see and balance between the liberty of the citizens and the timing when the bail is to be given to a particular accused.
Thank you so much for sharing, both of you. I think this will help us people understand more about bail parameters and also the bail strategies in economic offences. Thank you again for being part of this panel discussion.
Thank you very much.
Thank you so much,
Samarjit. Wonderful.
Same here, sir.
Platform.
Thank you so much. Highly grateful that we could be on the same panel.